Okay, I think we can start.
Hello, good evening, everyone. Welcome to Borneo International Center for Arbitration and Mediation's first evening talk entitled BIC TOK #1 Understanding the Rules. We have our first panel of this talk with us today, Datuk Mah Weng Kwai, our very own council member, together with Dr. Wong Foo Keong, Datuk Joy Appukuttan, and Mr. Goh Keng Tat. Without further ado, I will pass the floor to the moderator, Mr. Goh Keng Tat. Floor is yours, Mr. Goh.
Thank you, Sharifa. Well, hello everyone. Good evening. I'm moderating today's our inaugural BIC TOK session. I'm actually moderating from Vietnam. Therefore, unlike my fellow panelists, I am not wearing a suit. So, welcome everyone. So, let's get things on the road. We have, as Sharifa mentioned, our speakers today. We have Datuk Mah Weng Kwai, retired Court of Appeal judge and also past president of the Malaysian Bar. Datuk Joy Appukuttan, a very senior member of the Bar. And Dr. Wong Foo Keong, a senior arbitrator. And if any of you harbor hopes of becoming an arbitrator one day, Dr. Wong will be the right person to teach you. Right. Perhaps we can start with Datuk Mah. Can you tell the participants what BICAM is all about?
Sure. Thank you very much, Mr. Goh. And sorry to be interrupting your lovely vacation in Da Nang, in Vietnam. It's a pleasure, ladies and gentlemen, to be talking to you this evening as a council member of BICAM. And I note that our chairman of the council, Tan Sri David Wong, is listening in. And we do have a fairly large number of 16 or maybe even 20 participants for this event. This is the first of the series of discussions or talk series to create awareness and to inform practitioners and members of the public what BICAM is and what it stands for and what are the things that we hope to achieve. Now, as most of you will know that in West Malaysia or in Peninsular Malaysia, we have the AIAC, that's the Asian International Arbitration Center. That is the body that looks after all arbitrations and mediations in Peninsular Malaysia. The plan or the idea was to have a body equivalent to this in the form of BICAM, which is Borneo International Center for Arbitration and Mediation, located in KK. And hopefully one day we will have Sarawak join in as well under this flagship or under auspices of BICAM. So now there are various committees working under the or working within BICAM. We have the council, of course, we have got 10 council members, and we have this committee which we are having this talk under today is the Rules and Proceedings Committee. And we have various other committees that talks about admission and talking about composition and challenges and so on. So all aspects of arbitration are looked into in the BICAM under the rules. And I would want to just very quickly mention a few important points and then go on to listen to what Mr. Datuk Joy will be talking on mediation, and Dr. Wong will be speaking on arbitration generally. I do not want to duplicate what they're going to say, but I just want to go into some of the rules, the more pertinent rules, and some of the more important questions that perhaps people have in mind. Now, if you are an advocate and solicitor in Sabah, then of course you have absolutely no problem in appearing and acting as counsel or acting as an arbitrator under BICAM. But if you are a person from Peninsular Malaysia, then of course there are criteria to be followed if you are going to appear as a counsel in an arbitration case or in a mediation case or as an arbitrator. But I think things have been made much easier in that all you need is that for somebody to appear as a counsel, you just need to have ad hoc admission, and there will be no according to a circular issued by the Sabah Law Society, a circular which was sent out on the 15th of June this year. You can have ad hoc admission. There would be no objections raised by the State AG nor by the Sabah Law Society. And you can then appear as counsel, but you do need a work permit. But if you are coming in as an arbitrator from Peninsula Malaysia, then really all you need to do is to have a work permit. Yeah, you do not need to be admitted ad hoc. So those are the big change, and I would think that's very, very helpful for people who are thinking of doing work in Sabah. Of course, but like everything else, all procedures are always rules and regulations, and I can only do what is really necessary and to introduce you to the arbitration rules of BICAM. There are two sets of rules. One is the mediation rules, and one is the arbitration rules. Right? They are separate sets of rules, and I'm sure Datuk Joy and Dr. Wong will be highlighting these. But the arbitration rules are the 2023 rules. It came into force on the 1st of October this year, so it is fresh out of the oven, very, very recent rules. And you will find that it will cater for the appointment of arbitrators right down to how hearings are being held and how awards are being delivered. Yeah, and I would just say that before I go any further, I think what is very important in an arbitration agreement, there should be an arbitration clause, because if there's no agreement between parties to submit a matter or to refer a matter for arbitration, you can't force. It's not compulsory, right? So there should be an agreement on arbitration clause, and in these rules, there are standard BICAM arbitration clause drafted. Yeah, so have a look at the rules itself. I think you can pick up one of these booklets, if not mistaken. I think it's for free anyway, for the time being, perhaps. You can pick up one up and you can read for yourself what the standard clause is. It's been drafted after a lot of thought has been put in by council members and by all the experts in this field. You can have a direct arbitration clause. You can have a mediation -ARC clause, mediation cum arbitration clause, or you can have a BICAM, even a BICAM expedited arbitration clause, right? So, but basically the bottom line is that if you want to go for arbitration, there should be an agreement to do so. Then the next thing to consider, of course, is the number of arbitrators. Is the matter going to be dealt with by just one sole arbitrator or by a panel of 3? Now, of course, when it comes to nomination of arbitrators, it's usual for one party to propose a name and then to see whether the other party will agree with that name. And if there is, then that's fine. That person gets appointed. But if there's no agreement, then the matter will go back to the center for the nomination, right? And if there's provision for 3 arbitrators, same thing. One party will nominate one, and the second party will nominate another. And between the 2 arbitrators, they will then go ahead to appoint the presiding arbitrator. But bear in mind what is stated here in the BICAM rules on. Just give me a minute. This is about the appointment, and we have under this. You start off, of course, with the notice of arbitration. You give notice of arbitration to the other side, and you have the appointments. This will be under Rule 9 of the rules, where, and very quickly, just to give a bird's eye view of this, if the amount does not exceed 15 million ringgit, then, of course, BICAM can appoint a sole arbitrator. If it exceeds 15 million, then there's provision for appointment of 3 arbitrators, right? And this, of course, is subject to consent by parties. Okay, I think I will stop at that stage so that we listen to what the others will say, and I will fill up on the matters which are of interest to members. Thank you.
Thank you, Datuk Ma. Since we have already started with the arbitration rules, perhaps I will hand the floor to Dr. Wong to speak on the parameters and the principles of arbitration. Dr. Wong, you are muted.
Can you hear me now?
Yes.
Okay, that's good. Can I have my simple slide? Okay, good. Okay, I will speak in general about arbitration. A lot of you will know what arbitration is all about. So what I want to tie in today is arbitration vis-a-vis BICAM. What BICAM can do for arbitration in Sabah. All right. Now, as what Datuk has said, if there's a dispute and there is an arbitration clause, the matter must be referred to arbitration. All right. The contracts can be construction. It can be any form of contract. As long as you have an arbitration clause, then it's mandatory that it would have to go for arbitration. There are condition precedents to that. Some clauses will require mediation to be done or to be carried out before the real arbitration procedure could proceed. Now, in Malaysia, all our arbitrations are governed by the Arbitration Act 2005. Now, this is a monumental act, a very important act. Right. And it allows proceedings to be heard by arbitrators who are familiar with the trade. Now, the important thing about the Arbitration Act is that as compared to litigation, where you try to resolve disputes by the courts. Sorry, I got to cite something. Okay. It's that there is a good measure of finality in arbitral proceedings, right? Now that to me is cost and time effective. In litigation in the courts, there are just too many avenues for appeals. If an arbitration is done properly and there are no irregularities, by and large, an arbitration award is final, right? So it is a very important means of resolving disputes. Now, the thing about arbitration is that it can be conducted in a very friendly and conducive environment, unlike the courts, where you have young Arif sitting right above that, and everything is so imposing, isn't it? In a properly done arbitration, everybody is in a nice room, level with each other. There's no young Arif right at the top tier, and discussions can be held according to how the arbitrator or the parties would want it to be done. The whole idea is to resolve the dispute. So there's no strict procedures to follow, and the arbitrator and the parties can agree with a format as to how the dispute is presented by the parties, how they are defended, how the witnesses will be examined, and so on. And in fact, in arbitration, we do a lot of what we call hot tubbing, where a lot of witnesses of the same sort of classification can be brought together, and there will be probably a frank discussion, and the arbitrator can be there, possibly as a mediator and so on. Now, the other thing about arbitration is enforceability. of the awards. It can be done almost internationally. We have the New York Convention. And this is actually very suitable for international disputes, right? But it doesn't mean that the courts in Malaysia cannot deal with international disputes. But arbitration is, in fact, a very good forum where international disputes can actually be resolved, right? Now, for that to happen, and that's where BICAM comes in, right? For that to happen in East Malaysia, there must be a platform or avenue, right? So that arbitration can be facilitated. Now, in West Malaysia, we have the AIAC, right? But then, when you have disputes originating in East Malaysia, it will be difficult in terms of documentation, in terms of travel, in terms of time, and so on, for parties, the experts, the witnesses, to come to Kuala Lumpur to have the disputes heard, right? All this is all money, and in fact, those people who are here in KL will then be out of station. They cannot go back during the evening to look after things that they've left behind and so on. So actually, it is actually quite stressful for parties in East Malaysia to come to AIAC to have the dispute resolved, right? And that's where BICAM is a very important platform avenue that has been formed to facilitate dispute resolution for East Malaysians, right? And I think it's a very timely sort of for BICAM to be instituted, and we will see how cost-effective and time-effective it would be, right? Now, as what Datuk Ma has said, there are certain rules and procedures and regulations that has to be followed when arbitration is done under BICAM. But by and large, they should be quite familiar. Participants and partisans should be quite familiar with such rules and procedures. I mean, if you're familiar with the AIC rules and so on, BICAM will not pose too much of a problem, right? BICAM is there actually to facilitate the conduct of arbitration in Sabah and hopefully Sarawakians as well. Now, the fees that are charged by BICAM are reasonable. When I say reasonable, I'm comparing them with AIC charges, right? So all in all, it would be a lot more cost-effective for East Malaysians to have their disputes resolved in KK, right? And of course, the facilities in BICAM is very good, right? Facilities involve rooms, whatever facilities you would want to have a proper arbitration being held. And of course, food is a very important criteria. Hotels are there. So I will stop here by saying that, look, BICAM is a very good start for arbitration for the East Malaysian community. Thank you.
Mr. Goh, can I now add on to what Dr. Wong has said? There are a couple more points I'd like to highlight before we hear from Dr. Joy.
Absolutely.
I think it's important to get this in context. I do not think we should leave anyone, especially Sabahans, in fear that BICAM is set up so that all West Malaysians would come and flood the market in KK. That is not the idea. I think this has been made very clear. The whole idea of BICAM really is to set up this center to help Sabahans, to help Sarawakians in this part of Malaysia to have their own hub to have their own center. But of course, in starting it up, you will need assistance from whoever that can lend some expertise and some experience. And hence, that's why some of us have been approached and called upon to help set it up, to lead discussions and so on. But really, this is not to worry, not to have Sabah lawyers worry unduly to think that this is going to be something that will be monopolized by West Malaysians. So if you look at it from the context of Sabah lawyers, when you talk about arbitration, there are two roles you can play. One is to act as counsel, as you would, as counsel in a case in court, in litigation, or you act as an arbitrator. And as mentioned, you need to have empanelment to be an arbitrator. And briefly, to be an arbitrator, you need to have 15 years, at least 15 years of experience, of which 10 years of experience in arbitration. Out of the 15, 10 years in arbitration. And as a mediator, you need to have a track record of at least 2 cases to speak of as precedents. So the requirements are not unduly difficult. And with time, I'm sure people will be able to get the experience. And if you are local, then of course there's no worry about the appearance. You don't need to have this ad hoc admission to worry about. You don't need to have to worry about work permit and so on. That is for other guys from West Malaysia to think about. So, as mentioned by Dr. Wong, BICAM's premises are located in a very central position in KK. And there are lovely facilities. There are big rooms. And the last, I visited this during the launch, and we have small rooms, medium-sized rooms, large rooms. The big ones can take up to 23, 24 persons. The smaller ones, about 8 persons. So it will be just nice if it is an arbitration of a medium size. Usually it's no more than about 10 people in a room. These are all, of course, rental. You have full day charges and half day charges to be paid. And importantly, the proceedings can be recorded audially. And with this comes a transcription service. And I think BICAM is very proud to say that they have this system of voice-to-text service. So immediately, it's voice recognition, and you can have a transcription done very quickly. And I think this will be coming into online. You're going to start using this by February, I think, by next year. And there's also this case management system. So those of you who do go to court and are familiar with case management, yes, we have this case management system. All you have to do is to submit a case, and then everything else will be looked into. All right, so these are some of the minimum requirements about empanelment and so on. But going back then, to just quickly talk about some of the rules. So if you are an advocate and solicitor familiar with court proceedings, you will find that this is very much similar process in arbitration, because you will have to talk about your pleadings. Yeah, you have to look after your cost papers. You will have to talk about whether it is a multiple contract situation, or whether it's a joint of additional parties, and so on and so on. Consolidation of proceedings. These are all covered in the rules. But the only difference really between arbitration and the courts is that in court, you file your case, you go to court, you have absolutely no choice of whom you want to have to hear your case, right? But here you can nominate your arbitrator, and you can also, have the council appoint the arbitrators. You have issues on language. I was talking about pleadings, evidence, recording of evidence. You call witnesses, you call expert witnesses, closure of pleadings and proceedings, and so on. So these are very, very similar to the rules of court provisions. Yes, there's also provisions for costs and deposits. If the case is going on, parties will have to pay deposits to the council, to the center. And again, this is a situation where the losing party will have to pay the costs of the winning party. There are two sets of costs here, two sets of expenses. One is the administrative charges charged by the center, and the other is, of course, for costs or fees of the arbitrator. Yeah. So again, the Schedule 1 of the rules deal with registration fees, administration fees, and arbitrators' fees. And there is a scale, there's a schedule, and you do a calculation. It's all based on the quantum of claim and counterclaim. And from there, you work off, there's a formula. You look at the formula and you calculate how many percent is applicable and so on. And like everything else, parties will have to pay equal share of the fees. And again, there's a frequent question that has been asked is, what happens if the respondent doesn't want to pay his share? Well, the rules will provide that the first opportunity is given to the claimant to pay on behalf of the respondent. But if the claimant decides not to pay, then the council will have the authority to either suspend or even terminate the proceedings, right? Because unlike court, the court judges are paid by government. Here, arbitrators have to be paid by the parties. If no payment, sorry, the horse won't move. Right, back to you, Mr. Goh.
Thank you, Datuk Ma. Later, what we'll have is we'll have a Q&A session. I will pose some questions for both yourself and Dr. Wong based on what has been said. But now we'll move on to Datuk Joy Appukuttan, because as the name BICAM suggests, we are also a center for mediation. So, Dr. Joy, perhaps you could start by telling the participants here, what is the difference between mediation and arbitration, and how it will help the people in Sabah?
Yeah.
Over to you, Dr. Joy.
Thank you, Mr. Moderator, and my fellow panelists and speakers. And thank you for inviting me, BICAM. It's an opportunity to me to share some of my knowledge on mediation. Now, the difference between mediation and arbitration is quite foolproof in the sense that mediation is a prelude to any dispute, whether in court or in arbitration. So mediation is a form of assisting parties to reach a resolution of their dispute before parties actually take up the matter in court or arbitration. And even can happen even during the course of the arbitration or legal process. So mediation is a tool to assist resolution as much as any other modes of resolution, alternate resolutions are available. So let me just give you a bit of a rundown of where we get these laws on mediation, because one must bear in mind BICAM's role is premised on two things. One is mediation, the other is arbitration. The mediation itself applies to both domestic mediation as well as international mediation. So as to the laws, I will just take you to the next slide, just to quickly refer to the laws in the local context of the Mediation Act of 2012. And in international context, you have the United Nations Convention and International Settlement Agreements resulting from mediation, shortly or colloquially known as the Singapore Convention. And we have 56 or 55, actually to be now it's 55, the final country is not really been a signatory yet, but almost there. So we have 56 countries who are signatories to the convention. Some have ratified, some have not, some have made legislations to bring this into force for the local, into the local context. Now, I will just focus on BICAM itself. So let me just take you to the next slide and just give you a bit of a rundown of what we have in BICAM. The BICAM Center, Datuk Ma spoke about the arbitration clause, which is also BICAM's provides that a clause for mediation as well. And this is how it reads. And you will find this on BICAM's website as to the clause that requires the parties to actually refer their mediation processes to BICAM. This is just a guiding clause for parties to intend to use mediation as a tool of negotiations when they're drafting out the contracts. Even if there's no contracts for mediation, it doesn't mean that you're precluded from coming to BICAM. The facility in BICAM, as Datuk Ma has explained, has enormous. They have all the facilities that you need to carry out a mediation. Why mediation in BICAM? Simple. We only have one out in this part of the world, that is in Peninsular Malaysia. As far as mediation is concerned, in East Malaysia, we are running it through the court processes. Centers to assist parties to come to a mediation process is lacking, and BICAM is the one that's in the forefront of it. Bear in mind, mediation, BICAM is the domestic center for mediation as well as arbitration, unlike AIAC that is actually governed by international parties as well. Now, so if I move on to the next slide, you will find that the entire BICAM rules, which I intend to speak about, is found on the website itself. This is the link. That's a QR code if you want to look it up. And you've got a beautiful booklet that comes in this form, if you can see this. It's full of the rules, easy to understand and easy to digest. And these rules, if you compare them to the Singapore Convention rules, there are similarities to it. So we're not departing very far from what the norms are on the rules for mediation. So moving forward, what do we have in the process of the rules? Simplified. So to be able to move on to mediation, okay, if it's not provided contractually, you're looking at mediation being a voluntary process. In all instances, it's always without prejudice. All right, it's unless the parties unless the parties executed the settlement or settlement agreement arising from the mediation process. It's otherwise confidential, and parties are not at liberty to make any disclosure beyond the walls of mediation. Now, you take it in the context of the Mediation Act, it makes it very clear in Section 16, for instance, that anything that's discussed at the mediation is privileged. It cannot be the subject matter of discovery or admissible in evidence. So that's how mediation works. So it gives party the autonomy to discuss everything under the sun without prejudice, without fear of being disclosed anywhere else. Save and except, of course, if it boils down in elements of criminality or parties waive their right to it being issued, or it's a public document already available in the public domain. So apart from that, everything else is privileged and it's confidential. So that's the element of mediation you want to consider when you're looking into the process of resolving the dispute. So how does BICAM come into the picture? Let me just go to the next slide and give you the procedures which BICAM has set up. So you've got this probably about 8 steps that you need to do. It's a simple process, all very simplified for you to do. You know, it starts with submitting a request for mediation. You go to the request for the mediation at BICAM. You appoint the mediators, and then mediators are available for BICAM's list. And you go to the conduct of mediation. Termination of mediation comes in the end, and then if a settlement is reached, settlement is reached. And even if there's concurrent proceedings, whereas anywhere where there's arbitration or court process or any other alternate dispute resolution processes, you can still go through mediation. So let me take you to each of these elements as I speak now, so that you understand how this works. So when you the next slide will explain the process. So what do? You submit a request for mediation, okay? And you must provide the details, a statement that the dispute is referred to mediation, the names and parties and details and particulars, all has to be identified. That whether there's an existing mediation clause in your agreement. If there is such a mediation clause, then that would be the referral point for parties to mediate. If there is none, as I said earlier, it can be by voluntary basis. So you identify the documents in question, what the disputes are and what the issues are, and the claim, or as the case may be, the issue at hand. All right. So once you've done that, and then you go into the next statements made between the parties as a conduct in respect to the parties' seeking purpose, propose, and then you go into the proposal number of mediators. You know, if it's one, it's one. If it's 3, then it's 3. Then I'll come to that in a while later. So, and then of course the most important part, you pay BICAM the registration fee to mediate your mediation process. As Datuk Ma has eloquently put, you know, the horse doesn't move, there's no fee you pay. So that's how it works out here as well. All right. So moving on to the next slide, I just take you through the request for mediation. So if the request is made, mediation is made jointly, then that's no issue. The forms are signed and then submitted to BICAM, who will then facilitate the process. Now, if it's otherwise, then what do? The then, sorry, just give me a minute. I've got something that's hindering my webcam at the moment. Yeah, sorry. Okay. So if otherwise, then the parties submitting for mediation or request for mediation, the BICAM must notify the other party and inform BICAM of the details. Simple as that. So once party receives the request, the other party receives, he must reply within 21 days. If the other party doesn't reply within 21 days, what happens? The mediation gets rejected. That's it. You cannot compel parties to mediation unless there's agreement between the parties to do so. All right, that's the element of mediation. So if otherwise everything's in order, the mediation is deemed to commence by agreement of the parties. So that's how the mediation process starts. So if I take you to the next slide, what does BICAM do then? It's appointment of mediators. So as I mentioned earlier, the appointment could be joint appointment where you nominate one person, or if it's appointments for 3 mediators, then it'll be one by each party and then the third by BICAM itself. So what do you do after that? So if it's a sole mediator, then parties must agree to the named person, and you then decide who that sole mediator is. If otherwise, then it is left to BICAM to make that appointment, and which BICAM does so within 7 days. All right. So, and if there's a co-mediators, as I said earlier, each party should appoint one, and then within 7 days, once the names have been provided to BICAM, then BICAM then appoints a third person to be the mediator. Okay. Now, the other thing that you must bear in mind is, notwithstanding that there's a lot of party autonomy as to the appointment of mediators, but BICAM still makes that confirmation to ensure that all the appointed parties as mediators comply and are appointed under the BICAM rules. All right. So the next slide will take you through the next element, which is the mediators themselves. Dr. Ma has explained the qualification of arbitrators as well as mediators, the minimum requirements and all that. Simple. That's all you need to do to be engaged as a member or the mediator on the list of BICAM's mediators. So that's all you need to do. So it will come from BICAM's mediators, appointed under BICAM rules, and there must not be any conflict. Obviously, the material part of a mediator's appointment must ensure that he's not conflicted by either the party, the subject matter, or anything related thereto. So his independence is vital, and therefore he must be scrutinized to that effect. Notwithstanding that, even if the parties have jointly agreed to the appointment of that mediator. So if there's any conflict of any element of any sensible interference of that his independence, then parties can agree to, by consent, to replace the mediator. And that substitution of the mediator must also comply with the BICAM rules. As I've said, the BICAM rules are quite simple, quite easy to follow, and there's nothing untoward about having to comply with it. So I go to the next slide, which explains the conduct of the mediation. So what do you have here? The conduct of the mediation. Sorry, I'm just having a bit of an issue with my video. Okay. The conduct of the mediation is simple. It has to be concluded within 3 months. The mediator must complete its mediation within 3 months from the date of his appointment. So if it extends beyond 3 months, well, unless the parties agree by consent, that can be achieved. So otherwise, it has to be completed within 3 months. And the commencement of the mediation will commence with either a preliminary meeting, if the mediator requires one, i.e. where parties bring in information documents, and then for the mediator to assess, and then a mediation process will commence. So the mediation process itself, the mediator's mediation processes, it's open to the mediator. If it's a technical area, which, for example, it involves engineering or structural things to the effect, he may consult an independent consultant for that purpose. And that's subject to the discussions with the relevant parties to the mediation. And then so in the process of the mediation, the mediator will have both parties present. As many of you who've done court processes, who have attended court mediation, where parties are present, discussions are had, and the mediator hears both sides, or either jointly or separately, or he tries to achieve what is best according to the situation. All right, that's how the process works. Or you can do a combination of both. So the next level you must understand is as I've mentioned, I can't overemphasize the point, is that the element of confidentiality is important. The mediator will commence the whole proceeding to explain the processes, the without prejudice element, the importance of privilege, privacy, and confidentiality, so that parties are at liberty to discuss freely. And the whole purpose of mediation is to achieve a resolution to that dispute. All right. So this comes to the interesting part as who can be there at the mediation. If you are the parties are individuals, corporate companies or its likes, they can choose anybody to represent them to appear for that at that mediation. So lawyers, don't be afraid. You're not going to be out of the job. It's an opportunity for you to assist the parties as well through this mediation process. Likewise, like Dr. Wong and Dr. Ma had said earlier, you can also be a mediator listed in our BICAM, provided you comply with the rules and satisfy the requirements. Okay. Now, so I go to the next slide, and that is on the issue of termination of the mediation. So what happens at termination of mediation? Now, termination can take place in many forms. All right, that it will be on the basis of where a settlement is achieved after the entire process of mediation and settlement is achieved, or if the mediator decides efforts of mediation no longer is justified. You know, for example, if we've already reached the 3 months period since its appointment, the rules clearly say, hey, look, unless parties agree, the mediation is called off. It's end. There's no resolution to the matter. Then you've got there's elements of criminality or legality discovered by the mediator during the course of the mediation. If that happens, of course, he's got to put a full stop to the whole thing and say, hey, let's stop here and I have to terminate because of these elements that may prevail throughout the course of the mediation. And then if the parties themselves say, look, I've given up, I'm not going to process the whole thing, and I'm going to put an end to the whole thing. So again, it's up to the parties at that material time. So these are the areas in which the rules provide as to how the mediation can be terminated. So let me take the first part, which is the purpose of the mediation, which is settlement, which is my next slide on this matter. So what happens when there's a settlement? So when there's a settlement reached in the mediation process, so in the BICAM rules, it provides that you will then refer the matter to an arbitral tribunal to be appointed by BICAM for the purpose of recording the consent award. The arbitral award then will be registered with the court for enforcement. Otherwise, if not, then it becomes a settlement between the parties. All right. So that's how it works out. So the issue that comes to mind as the moderator put it to me was, what happens? What's the difference between arbitration and mediation? I've given a brief explanation there. So let me go to the next slide to take it to one level ahead, and to explain that, notwithstanding that you have concurrent proceedings, whether it's arbitration, whether it's in court, or whether it's in any other alternative dispute resolution, i.e. a tribunal. Now these days we've got many tribunals, strata management tribunal, we've got the housing tribunal, we've got many other issues down and likes, which are alternative dispute resolution processes. So notwithstanding you have any of these processes that plays up, okay, you can still proceed with the mediation if you initiated a BICAM, or even after. So there is no restriction to that efforts. So it gives you an avenue to resolve the matter, notwithstanding whatever other concurrent proceedings you have with them. It doesn't operate as a stay. Let's be clear about it. Mediation doesn't operate as a stay. It's very clear in the rules as well in the statute, and the Mediation Act makes it very clear as well. So you can proceed with it, all right, notwithstanding whatever happens in the other proceedings. Okay, so I have more or less put that in a nutshell for you, and what would have been a simplified rules. I've simplified it even further for your understanding. Hope that helps you to understand what mediation and BICAM is all about. Thank you very much. Over to you.
Thank you. Thank you.
Sorry.
Mr. Goh, can I chip in again at this juncture, if I may? Have you finished?
Sorry, I just got one more slide on the cost.
Oh, okay. Sorry.
I was going to exclude it, but you mentioned something of cost earlier. And on the arbitration side, this is the cost on the fees on mediation.
Right.
So this is what it's all in the rules. So as you can see, that two sets of costs, one for domestic mediation, one for international mediation. It's relatively reasonable. You will not get this anywhere else. If you comparatively in this region, for international arbitrations, one look at this, for example, the Singapore Mediation Center or the Hong Kong or the centers and all that, you'll find the cost is much more substantial. So this is an opportunity for you to consider BICAM as an alternative. All right. So this is what it is. Thank you very much. Sorry.
Thank you. Mr.
Yes,
Arbitrator, Mr. Moderator, can I just chip in? Just to highlight one point. Sorry, at the expense of repetition, perhaps. But I think since I'm not quite sure who the participants are who are listening in now, but I think that there are some very young lawyers. I am told that there may be some pupils in chambers as well that may be listening. So for their benefit, I just want to highlight the very major difference between litigation, arbitration, and mediation. Now, as you're all aware, you as a trained lawyer, you go to court, you fight a case in court, you litigate a case, and the decision is made by the court, made by the judge, and of course there's the appeal process. Now, in arbitration, much like in a court case, the decision is made by the arbitrator. Right, the decision is made by the arbitrator, and of course, this is governed by the Arbitration Act 2005. Now, you cannot willy-nilly set aside the award given by an arbitrator just because you disagree with what the finding is. Right, there have to be very, very strong grounds, and usually you will only succeed if there's bias and prejudice and so on, and even a wrong assessment of the facts will not be sufficient to set aside an award. But why I say this is that in mediation, and as Dr. Joy has mentioned, in mediation, the issues are very much in the hands of the parties. And the mediator is there as a facilitator to help parties discuss the case, to look at all the various angles of the case, to draw them out into negotiations and so on. But importantly, the decision is not made by the mediator, right? So this is a very important distinction. Whatever agreement that's made, if successful, will be by consent of parties, hence the consent settlement agreement. Yeah, and you'll be surprised that in practice, in real life, you can even have a mediation between a borrower or somebody who's owing a bank huge sums of money, and you'll be wondering why would a bank want to go into mediation with a defaulting borrower. Well, the reason is quite simple, because they know if they go for litigation, they go for broke, they'll get a paper judgment. Whereas if they go for mediation, and if parties can negotiate and talk about timelines and installments and so on, at the end of the day, they may get something back in return. And the banks are prepared to take a big haircut when it comes to this sort of thing. So this is just one example. But the important point here to remember is that it is the parties that make the decision, not the mediator. Thank you, Mr. Goh. Thank you, Datuk Joy.
Well, we've heard today about how money moves the horse. So, Datuk Joy, your last slide, which talked about, we showed us the fee structure for mediation. So I think you'd agree with me, it takes a lot less to move a horse in mediation, isn't it?
It does. It does. I think you can pull a cart with that kind of fees, So, so it is reasonable. It is affordable, and it is something we want to encourage. The idea, as what Dato' Ma has put it very eloquently earlier, of the purpose of mediation. Let's not forget, even taking the scenario Dato' Ma has started, why do bankers want to go into a settlement with a borrower? It also works for the borrower. Court proceedings these days, when a suit is taken up, it gets flagged on CTOS. It's worse off for his credit. Whereas when you go for mediation, it works for all parties. Can achieve a resolution and restructure his loan and financing without affecting his creditability. So there is a benefit in all this at the end of the day.
So that's actually a very good point, and one that the lawyers who are listening into can take to their clients and say, let's consider mediation.
Yeah.
Right. This question is directed to Dato' Ma. Earlier, Dr. Wong said, arbitration proceedings are different from court proceedings where there is no young RF, there's no judge, and everyone is equal in arbitration. Now, we all know that among the empaneled arbitrators in BICAM, there are quite a few retired judges, including yourself. So when a
Yeah.
retired judge sits as an arbitrator, does he use a different mindset? Does he put his past trainings aside?
Well, good question. I was just talking about empanelment of arbitrators. Just now I was saying about 15 years post-qualification experience and so on. And one section is for retired judges of superior courts. They can be appointed as arbitrators. Now, sitting on the bench, yes, things are more structured, things are more formal. To begin with, the lawyers will stand up to address the court and address them as Young Arif or whatever other title they want to. But in arbitration, things are more relaxed, as Dr. Wong has mentioned. It is, everybody's seated at a table, nobody is standing up. The arbitrator is either addressed as Mr. Arbitrator or just Mr. Chairman, or some short of calling him Oi, everything is acceptable. So, you will find that it is not as stressful. Parties can take a lot more time to present their case. And in fact, an arbitrator should not be entering the arena. Much like a judge, you shouldn't be entering the arena to restrict the number of witnesses or to really curtail the way witnesses are going to give evidence. But by and large, it is more, I think it's the whole setup, the whole system is more lax. And you can also, for example, one major process is what is known as hot tubbing. This is what Dr. Wong has mentioned. Hot tubbing here actually means getting expert witnesses from both sides, the claimant as well as the respondent, to not literally sit in the tub, but to face each other at a table to sort things out before the arbitration actually gets going. Or it can be done during, but preferably it should be done before, so that the parameters of the expert's evidence can be determined, and that will help in the course of the arbitration itself. So there are various factors which are very advantageous to arbitration. The only downside that people will say is that, well, you go to court, it's much cheaper, but you go to arbitration, you have to pay for not just admin fees, but you have to pay for arbitrators' fees. So the cost factor is definitely something that parties will have to consider. Thanks.
So hot tubbing would be to narrow down the issues. And when we talked about fees, not only are we paying for the facilities, but I believe we are also paying for the experience that the arbitrators bring to the table, aren't we?
Oh yes, of course. I think you are getting the attention and the application of knowledge by an arbitrator. Of course, there are different cases have got different levels of expertise involved, and if you have really complex cases, then you have to have a lot more attention paid by the arbitrator. And that's why sometimes if it's a big claim, it doesn't just stop at one arbitrator. There will be a panel of 3. Yeah.
Now, this next question is for Dr. Wong. We were just speaking about the empanelment of arbitrators and even mediators. And based on the requirements by BICAM, it is quite strict. We require certain qualities to be met, experience and years of similar practice. Now, as a trainer for arbitrators, how important is the quality of arbitrators hearing a matter?
I would say it's absolutely important. Now, I've trained arbitrators for the past 20 years under the Chartered Institute of Arbitrators, right? We want future arbitrators to understand what is required of them, to know the rules properly, and I think the important thing is the conduct. Arbitrators must know how to conduct themselves. Now, I've mentioned the easy manner in which arbitration can be held, but that is with a caveat that the arbitrator must be very careful about irregularities, about its own conduct, and so on. Now, the Chartered Institute of Arbitrators have always encouraged arbitrators not to abide so strictly by court procedures. That's where arbitration should differ from litigation. But then when I was doing my my chartered interview, I was asked by the examiner, would you be running a risk by being too carefree, not to follow strict court rules which have been tested over the ages? Right. Now, important thing about this examination is that you give a wrong answer, you fail. So it's very important that we have to be very careful when we answer such a question. And I remember I did say that, look, if it is a matter that is very complicated, I will follow the judges. I will follow court rules. If the matter is not as strict and so on, I would lay down some rules. The important thing for arbitrators, unlike in court, is that arbitrators can make rules. Arbitrators can enforce rules and put power upon themselves. There are opportunities for arbitrators to do that in the preliminary meeting, and in fact, in getting the parties to agree to give the arbitrator certain rules and certain flexibility. The whole issue is to facilitate the dispute resolution, right? Let the parties know, look, we are not going to go through court procedures because it's going to be very arduous. We can go through it in this manner. If you all agree, me as the arbitrator, I can be given certain powers to direct the proceedings so that everybody will benefit.
Thank you, Dr. Wong.
Okay, thank you.
Right. Okay, we have some time. What about the participants? Do the participants have any questions? Feel free to speak up. This is interactive. Because if there's no questions, we can start asking them questions to see whether they've been sleeping during the seminar. Anyone? Any young lawyers, pupils in chambers who wish to ask questions? Oh, someone left. I suppose we will not be asking them questions. So one more area which I found interesting. Datuk Ma, you said earlier that this BICAM is not, how we say, a backdoor entry for Semenanjung lawyers to practice in Sabah and Sarawak. I've gone through the rules. It appears that we can apply for the work permit and ad hoc admission when it comes to sitting either as an arbitrator or as counsel in an arbitration proceedings. But will I be correct to say that such ad hoc admission does not extend to enforcement proceedings in the courts?
Yes, absolutely. You're right on that point. To be counsel or to be an arbitrator, you need, as I said, to be counsel, you need ad hoc admission plus work permit. And as an arbitrator, you need the work permit. But when it comes to enforcement of an award, this has to be done through a local Sabah lawyer. Yeah, the counsel from Peninsula will not be allowed to do that. It's interesting to know that you have mentioned a word that is a backdoor way of getting into Sabah. Well, no, I don't think it is a backdoor way because it's really only limited to arbitration and mediation. This is an exception, a major exception that's been given. And I think this is necessary, as I was saying, because mediation and arbitration in Sabah, in Borneo, is in its infancy stages. I will see a time over the years that once they are firmly, the feet are firmly planted on the ground, this might be, there might be a change in the rules. But I am a positivist, and I've always been thinking and hoping that one day, East and West Malaysia, Sabah, Sarawak Peninsula, we will all be one, and I don't have to show my IC when I want to go to Sabah. I think it has to come about one day. Hopefully.
Correct. And I believe there's a saying, every day is a learning process. What Sabah lawyers can benefit from the Semenanjung participation is they will be able to see how Semenanjung lawyers conduct themselves and conduct the process of arbitration and mediation as well. It is useful. And similarly, Semenanjung lawyers will be able to benefit from the local knowledge that the Sabahan lawyers would possess, correct?
Absolutely, yeah. Can I just add, gentlemen, as far as BICAM is concerned, I think the strong points for parties to actually use the BICAM facilities and BICAM rules is that it's meant to be simple, concise, and user-friendly. So give it a shot, and you'll find that there is, on purpose, that there's minimal interference, minimal institutional interference. You will not get the chairman of the council or getting anybody telling you what to do all the time. And very much is left to the arbitrator, because at the end of the day, you are exercising a judicial function. So whether in court it's a fully judicial function or as an arbitrator it's a quasi-judicial function, there must be fairness, there must be reasonableness, and there must be a whole lot of integrity in the process. Otherwise, mediation and arbitration will fall flat if people think that things can be compromised just because, you know, it is not in a court setting. And yeah, BICAM refers to the ancestral framework. So there's a lot of strength and positivism in those rules. And I think the tendency also is always to keep up with the latest trends in arbitration. And that's the work of the council, to keep updating so that we can better ourselves all the time. Thank you.
So when we go through the rules, I think for arbitration, there are 36 sections. And for mediation, there's only 12 rules. So it should be very straightforward for people who want to start participating in mediation and arbitration. So, okay. I think we have just overshot our time by 4 minutes. Is there are there any questions from the participants?
Good evening.
Yes, who's speaking?
Hi, speakers and moderators. My name is Jessie. Thank you for the insightful session. I would just like to ask a question on mediation. Just now, Datuk Joy mentioned that mediator has to conclude the mediation within 3 months from the date of appointment. So my question is, what would happen if the mediation is not concluded within 3 months? For instance, a settlement could not be achieved between both parties. Thank you.
Thank you, Ms. Chiu. Very simple. The rules, BICAM rules provide that we have to complete, my gosh, I'm getting tongue twisted here. Complete the mediation within 3 months of the mediator's appointment. So the mediator will have to make all efforts as he can, as much as parties to also to participate, to ensure that there is a conclusion to the whole thing. If they cannot be concluded within 3 months, automatically it terminates unless the parties themselves agree to extend the time. So it's at the hands of the parties to decide how they want to move on this on mediation. So it's not so much governed by anything else apart from the parties to decide how they want to move forward. If they're really genuinely interested in resolving the matter, then if 3 months is insufficient, they can mutually agree to extend the time.
Thank you, Jessie, for that question.
Thank you.
Can I add to that answer?
Questions?
Can I add to that answer?
Oh, yes, of course.
Thank you for that question, Ms. Chiu. I think the timeline of 3 months is merely to set out the parameters of the whole process. But in actual fact, and I have done many court-led mediations, and the experience will tell me that once you start a case in the morning, you really want to finish off the arbitration before the day is out. Because once you have a postponement, even to the next day, parties will come back and there will be a change, a major change in thinking, and the gap becomes bigger. So in reality and in practical terms, it should be something which is all the facts are marshaled together and get the parties to really dive deep into the negotiations to try to achieve settlement within the day. I mean, you know, parties are always being advised by solicitors, and if there's a postponement, they'll go back, there'll be a post-mortem of what has been said, and they'll say, oh, should have said this, you should have said that, and different ideas will come to mind, and that will complicate any chances of settlement. That's my experience. Thanks.
Do we have any more questions from
Now,
the
maybe I can
participants?
add a little bit here. I've done quite a bit of mediation. The longest mediation session I've taken was only 3 days. Force the parties to think. Force the council to come to agreement, put everything down on the table. And to me, normally for mediation cases, 3 days is more than sufficient, right? So 3 months is actually more than sufficient because you are allowing parties to go back to think, to articulate, and then to give more problems, right? Mediation is supposed to be quick and decisive, right? If the parties are prepared to mediate, then they should be in for it. I mean, they should not be in there to mediate just for the sake of getting through the process. So like I was saying, I've done quite a bit of mediation, not more than 3 days, would normally get the deal done. If you can't get it done in 3 continuous days, you should call it off. Right?
We should be mediating, not meditating.
Yes.
Any further questions? Oh,
Thank you for the answer.
Thank you for asking.
thank you for asking and participating. Right.
I see Tan Sri David Wong is still tuned in. And probably he has some comments or some words of advice for us. Tan Sri David?
Please share.
Thank you, Dharma. Actually, I turned on my camera to be in the last bit. Actually, firstly to thank you guys, the 4 of you. Dr. Wong, how are you? First time I met you. Of course, Mr. Goh, Dr. Ma, and Dr. Joy.
I am fine, thank you.
Very familiar with me.
Yeah.
So I thank the 4 of you for doing the first of BICAM series, and I don't think it's an accident that we all get all West Malaysians to be in our first series. Like the moderator said, we in East Malaysia, arbitration and mediation is actually quite new. Our market is quite small, and we are keen to learn from you guys. And that's why when we set up BICAM, one of our first thing we did was to convince the lawyers in Sabah to open up the market, right? Without opening up the market, it is not feasible. The opening up is for us is a win-win situation. It's another market for us to learn, and when after much learning, we will be as good as you guys are over in the West, and we want to learn from your expertise as well. And then for West Malaysian lawyers, it is another market is open for you guys, right? We are in a borderless world. We can't live, with our with borders surrounding us. In a cocoon, right? And especially arbitration. So hence, if you look at our list of arbitrators and mediators or internationals, personalities. So, we hope to give an alternative to people in this region anyway, to have their matters mediated or arbitrated. So I'm very grateful for the 4 of you guys to spend some time with us. And this is just a small step. I know that it's just a lot of hard work to go. But I don't know, Dr. Wong, I don't, we have the first case registered with BICAM already. A notice of arbitration has been filed with our center, I think, last week. So
very good.
So it's a small step. It's a local arbitration, so it's a small step, and we hope that the next step is, when the local arbitration, but the clients engage West Malaysian lawyers, understandable if it's a big claim, right? That even though the clause says it should be done by AIC, we hope that the parties will look at us and say, hey, it's much more economical to do it in BICAM, and your representation, your counsel would not be prejudiced because they're able to get ad hoc admissions in Sabah to do the arbitration in BICAM. So we're moving step by step, but hopefully one day we will be a body that people will look up to. The other thing, I don't know whether Dr. Wong or Datuk Joy or Mr. Goh would know, our state governments is really behind this, and instruction has been given to all the departments and all the GLCs to incorporate the BICAM model clause. So, one day, it will take 2 years gestation period and all that, but we are making a start. In our view, I think a formal start, and hopefully it will with the expertise like you guys, we're able to move forward and be successful. Roger is there. Roger, of course, one of the architects of BICAM when he was the president of Sabah Law Society. So, Roger, you want to have a say before we close off, and so I can have my shower at about 9 o'clock in the evening. I just had my dinner, rush back here to join you guys.
Thanks, Sri. It will be a consolidation. It will be good to know that when we started off in those good KLRCA days, there were only a few cases coming in annually. And the common remark that we hear is that, why should we go for arbitration? It's like having a game of Russian roulette. Those were the good old days where the trust in arbitrators, the trust in the arbitration process was very low, right? I think Datuk Ma will know what I'm talking about. Those were the days that nobody wants to go for arbitration. And there was no respect for arbitrators. I used the word that, hey, going for arbitration is like Russian roulette. It depends how it rolls, Not so nowadays. A concerted effort was put in to educate lawyers and non-lawyers on arbitration. In fact, we were drawing in a lot of expertise from the Chartered Institute of Arbitrators, which I would suggest that Sabah would do the same, right? Because they are a pool of good knowledge and experience. With that, I think arbitration in Sabah and Sarawak can be promoted and improved tremendously, right? Now, we have gone through a long road and process in West Malaysia. We are not where we are now because we were good from the beginning. We were very poor to start off with, I have to say, right? So it's a good start. Everything must start from somewhere. And I think BICAM has good examples to rely upon. The AIAC is already there, and we have very good examples to follow. So I think BICAM should not have too much of a problem to progress to the next stage. Okay, thank you.
Okay.
I just wanted to make a very quick last comment before everyone left. Being that BICAM, of course, although it's set in Sabah, it can be used anywhere in Malaysia or anywhere in the world. So for our speakers, thank you so much for talking and sharing with everyone here. I know most of the participants I can see are Sabahans, but do please help spread the word that, of course, BICAM rules can be used for arbitrations in anywhere in Malaysia. You can name the seat of arbitration wherever you want it to be and just use BICAM rules, for example, and you can have the arbitration or mediation done physically in West Malaysia. So it is an arbitration center for the whole of Malaysia. I just wanted to end with that because rather than just focusing on Sabah and Sarawak, it is something that can be used anywhere in Malaysia.
Thank you, Roger. All right.
Yep.
Do we have anyone else have anything else to add? Else we can end the session now. But thank you everyone for coming to the inaugural Big Talk. Hope to see all of you again. And thank you, Tan Sri David, for giving the four of us the opportunity to be the first speakers and the first panelists in the Big Talk series.
Our privilege,
you.
our privilege. Thank you to you guys.
Thank you very much. Continue
you.
your holidays, Mr. Goh and Danang, but don't forget to come back.
I will.
Bye-bye.
I think the Vietnamese would want me.
Thanks.
Thank you,
Thank you.
Thank you, guys. Thank you.
Thank you, everybody.
Thank you, everybody.
Bye.